Privileged to announce this panel, Corporate Crisis Management, how to handle a major internal investigation and/or whistleblower. Our moderator is Patrick Otlewski from King & Spalding, where he's a partner in Chicago. He previously served as an assistant U.S. attorney in the Northern District of Illinois. Next to him is Ann Gittleman. Ann's a managing director with Kroll in New York. She also serves as Kroll's co-head of North America Expert Services. Seated next to Ann is Felicia Manno, a global chief in investigations counsel. The global chief litigation and investigation counsels with GE Healthcare in Chicago. Ann previously served as an assistant U.S. attorney, most recently as the deputy chief of financial crimes and special prosecutions. And seated next to Ann is John Mitchell. John's a counsel with Willkie Farr in Chicago. He also previously served as an assistant U.S. attorney in the Northern District, and prior to that, he served in the SEC Chicago Regional Office and the Division of Enforcement. Patrick, I'll turn it over to you.
All right. Thank you. It's great to see everyone. We've got a great panel, and we're really lucky to have someone in-house, Felicia, here to share her perspective on managing a crisis. And I think the best place for us to start is, what is a crisis? Crisis is often in the eye of the beholder. You know, sometimes it can feel like everything is a crisis, especially when you're outside counsel and someone calls you up and they feel like it sounds like their hair is on fire and they need you to come in right now and get to work. But I think, Felicia, you know, given you've been at GE Healthcare, a really large public company for some time, if you treated everything that came across your plate as a crisis, A, you wouldn't have any hair, and B, you know, your legal bill would be super high. So how do you define what a crisis is for a public company?
Yeah, so thanks, Patrick. It's true what you say. So I've been there almost 7 years, and probably the first 6 months, there were a lot more things that seemed like a crisis than seem to me now. It's been my experience that you get a lot of hair on fire at the beginning, and probably 95% of those turn into this wasn't that big of a deal, if a deal at all. So when I think of a crisis now, I mean, to be fair, so we're a global company, and I think we're a healthcare company, a medical device company, and so safety and quality are that would be a real crisis, right? If we had a safety and quality issue. Mm-hmm. There's other things that are going on, of course, geopolitically, you know, other challenges. But for purposes of this presentation, I mean, I think the most obvious example is someone in your C-suite is arrested, or there's, you know, an announcement of a criminal investigation from DOJ and a parallel investigation from SEC. You know, now you're worried about all of your shareholders and securities class actions at the same time, and there's a whistleblower who's going to the New York Times in the morning. I mean, I think every public company would say that rises to the very, very top of the chart.
No. And look, we've seen that happen plenty of times recently, right? We have had Nestle, Kroger, Norfolk Southern. I think you can go down the list. You know, there has been C-suite misconduct that's led to corporate crises across the country. From a public company perspective, you know, do you think your calculus on what is a crisis to you depends upon, you know, strict materiality, you know, the quantitative, qualitative assessment that you're thinking, that your disclosure counsel comes to you and says, well, if it's not quantitatively or qualitatively material, you know, we don't have to disclose? Does that trigger it at all, or is it?
I mean, that is one factor, right? I mean, in thinking, so in terms of disclosing it in a Q or a K, you're talking about, mm-hmm. Yes. I mean, so look, I mean, just the party line, of course, is, you know, you do a materiality analysis with quantitative and qualitative factors. You are guided by, of course, the FASB accounting standards and SEC regulations. But separate and apart from all of that, there, you know, reputational risks, right? I mean, or some things you can't put a dollar amount. I always say, like, litigation matters are a lot easier, you know, in thinking about, is exposure probable? Is the amount estimable? Is that amount material? But when it comes to government investigations, you all know, you know, you're supposed to disclose a investigation that is the government is contemplating a legal proceeding. And there's all sorts of, if you go online, there's all sorts of opinions about what contemplated means. And yes, you have to in those circumstances. But what about if you there's underwriters, right, for a certain transaction, or you're doing due diligence for an acquisition or a merger. There's all sorts of other factors where you would think, separate and apart from the have to, should I?
So, Anne, let's talk a little bit about reacting to a crisis. Obviously you can't anticipate every crisis that's going to hit, otherwise it wouldn't necessarily be a crisis. But from your perspective, what are some things, maybe top 3 things you think in-house counsel, compliance team, internal audit can be thinking about to manage a crisis or react to it in the right way when it hits?
Yeah, that's a really good point. And I've been involved in, crisis situations at companies that are, I'll call them well-oiled machines, where they have a plan. And I'll go into a little bit more detail about that. And I've been involved in crisis situations in companies that haven't even thought of a plan. And ends up being so much more costly for them, for the people that they have to hire and the work that they have to do, and just containing it becomes very problematic. But I'd really say that the number one thing is to have a crisis management plan. And what that means is you have a team of people internal that you can point to, that you can go to, that know what to do when a crisis arises. And just like Felicia said, a crisis can take different shapes and forms, but those people should be prepared for all of those shapes and forms. And also, if you're an international company, you might want to ensure that you have counsel in all your different locations, right? So if you're in, say Nigeria, and you have a location there, you have to have local counsel there that can advise you on the laws and everything and so you're not searching for people to clear conflicts at the time a crisis is arising. So that's sort of the first thing. The second thing is, maintaining privilege, bringing in outside counsel, bringing in your forensic accountants, bringing in your PR people to ensure that the messaging is contained. And I would say sort of lastly, understanding what the crisis is, how far, how wide, how deep it goes. And I know that can be a much longer process, but trying to get your hands around it and communicating it internally and externally with one voice. I would say that those are the 3 things that pop into my head.
John, what's your take? What are, if you had to think about it, 3 things that a company could do right now to make sure that whatever the crisis is?
Yeah, the most important for sure, totally agree with Ann, is the idea of having the plan in place and the team in place. Because, anybody who works in this space knows that, especially when you're dealing with public companies, the one guarantee that when a crisis pops up is that it's going to be time sensitive. And so getting in play all the things that you can control ahead of time, trying to get ahead of those. And the most important, I think, though, is having a team in place that everybody knows that if there is a crisis, that team is going to get together and implement a plan that you've kind of thought through ahead of time. Exactly how that's going to work out, of course, will be dictated by what the crisis is, but those are things you can control. A couple other things that come to mind are, one is, we're going to be talking a little bit about how whistleblowers play into this, and I think making sure that you have a really strong and well-publicized whistleblower program, I think is really an important factor, an important thing that you can do before a crisis hits. And then the last is what you could do ahead of time is really, of course, everybody wants to have and has or tries to have a strong internal controls and a strong compliance program. If you do have that, if you really have a great internal controls and a really strong compliance program, it makes it less likely that there's going to be a crisis, but it also, if the crisis hits, you are just better positioned if you have a really strong compliance program in place ahead of time. So those are the 3 things that come to mind for me.
So, Felicia, I'm going to ask you a slightly different question, not about the 3 things you would do in advance. Who are the first 3 people you call when a crisis hits?
In the scenario that
Sure.
Well, assuming that it's not my general counsel who's been arrested, I of course would, I would call him, I would call comms, our communications, right, who, to your point, would make sure that there's external and internal consistency in communication. And then, depending on the issue, I would also call and make sure that we were preserving all documents immediately. Those would probably be my first 3 calls.
when does outside counsel get called?
Oh, I'm so sorry that was not the first thing to come to mind. No, just for our particular company, we have our model is do a lot internally, of course, and so we have a lot of resources that we would do the initial what is going on, and can still put that under privilege given my title and given the way that we have governance in our legal function. But you can bet if somebody in the C-suite is arrested, we'd be hiring counsel the next day. We'd also be notifying the audit committee, probably within the hour of that happening through the general counsel as well. So that would happen quickly. I think somebody else said it on a previous panel, but we would, in that scenario, we'd be hiring consultants. We'd want to make sure that we had people, even if we didn't need them ultimately, but already engaged, can talk to them under privilege, and any PR consultant, crisis communicator, hired under privilege.
So one of the things that we encounter a lot at King and Spalding is, when you have C-suite misconduct, allegations of it, when do you get the board involved? And how do you get the board involved, especially when you're dealing with something like the CEO?
That would be immediate. That would be immediate. If it were lower in the organization, say it was, 3 levels down from the CEO, that would not be happening. An arrest, yes, but if it were just a subpoena, perhaps, and it was, I don't know that would happen immediately. You'd sort of have a day or two to figure it out. But in the scenario we had, it's instantaneous in a public company like ours. And the auditor, by the way, our external auditor as well.
Mm-hmm. Well, one of the things that we often see is when the CEO is implicated, and whether it's something that's publicly announced, or there's indications that it's going to be publicly announced, or there's a concern raised internally that implicates the CEO, one of the biggest challenges is that your CEO is often on the board of directors. And so when you take the issue to the board, you have to decide who on the board you're going to take it to. Is it the chair? Is it the lead independent director? Is it the chair of the audit committee? And then figuring out, to the point of privilege, how do you manifest and maintain that privilege over the investigation, especially if it's a board-driven investigation, in a way that boxes out the CEO, right? Because you don't want that CEO to have the ability either to be read into what's going on as part of the investigation day to day, but also, in order to ensure that the board's actions are taken credibly afterwards, if some disclosure has to occur, and to ensure objectivity, right? That CEO isn't putting his thumb on the scale. So it gets really complicated really fast. And I think being quick to call up that lead independent director or chair of that audit committee can be really important. John, what's your take?
I was actually going to be talking on it, but a different point. But I just absolutely agree with what you said, and I'm actually going to pass.
So one of the things that I think is always important when thinking about a crisis, and I think you both touched on it, is disclosure. And why don't you just kick us off? What are some of the disclosure considerations that a company needs to be thinking about when that investigation kicks off?
Yeah, that's a great point. I look at it from an accounting perspective, disclosure. I was a prior auditor in my day, and if something is material, which Felicia also pointed out before, whether materiality is quantitatively material or qualitatively material. And so those are the things that I think you need to pay attention to when performing the investigation, ensuring that you're communicating it to your client on an ongoing basis so that they understand when those issues arise.
What about with external auditors? There's anyone who's dealt with an internal investigation, and I'm sure there's plenty of external auditors in the room or firms that have that arm. External auditors often want to kick down the door, right? Want to get underneath the tent, stick their nose under there and find out what's happening, right? Because they're going to get management rep letters. They're going to get disclosures and the like, and they're going to have to sign off. How do you manage that relationship with external auditors when you're in the midst of a crisis?
It's tricky, right? Because I agree with everything that you say. And frankly, I understand it both from the view of an auditor, because I was one, and now investigations, right? Where you do not want to share anything with the auditors that aren't based in factual evidence, right? And facts change as the investigation evolves, right? So you could think, something happened in the beginning of an investigation and it looks really bad and it looks horrible for the company, but then as you unwind it, you figure out, oh wait, it was just an error and it was backed out down the road, so there really isn't any impact to the ultimate financial statements. So I think really being careful in your communications to the auditors are important for both parties, right? For both parties, that you're not communicating anything that's erroneous and then they're relying on it to the detriment of the company. I think also a tricky issue is privilege, right? Because it's the company's privilege, right? And so oftentimes I'll have external auditors tell me, well, what are your search terms? I want you to use these search terms. I want you to go down these rabbit holes. And so, it becomes a very slippery slope with one, you start to share the internal mechanisms of that investigation. And so are you then, breaching privilege by sharing too much information, right? So I think it's a very delicate situation, but overall, you have to look at your auditors as partners together in basically auditing your financial statements. But I really think you have to be careful along the way, the information that you do share.
Felicia, I'm sure you have to deal with external auditors, every quarter, probably more frequently than that. I'm sure you have great relationships with your external auditors. What are some tips that you have for the group about how to manage that relationship in the middle of a crisis when facts are evolving, you don't know a lot, and there's that privilege risk that and so clearly and crisply articulated?
So at base, you have to be able to come to that conversation with a relationship based on trust and credibility prior to that. I mean, I spend a lot of time with our auditors. I wouldn't say that I overshare, but in talking to them, I think that I share more than other clients, which is letting them know ahead of time, if something is wrong, you're going to hear it from me. You're not going to have to ask me about it. And so in that sort of scenario, I agree with Ann. I mean, it's, I just know the facts, but I would, this is preliminary, and they are sophisticated enough to have seen me tell them before, this is preliminary, it turns out to be nothing, okay? And so there's a bit of track record. I will say I really push back on the tell me your search terms and all of that, because I find that it is privileged. And we were saying earlier, I've even had auditors say, well, if you don't have to send it in writing, you can just tell me. I'm like, well, that is still a waiver of privilege, okay? Like, wink, wink. So you just have to, you got to they're doing their job. They want to be able to sign something that says that they can rely. So you hire the best outside counsel you can. You share with them why you've done that, process-wise what you're doing. And I think if you have that relationship, they'll give you some latitude.
Yeah, no, and that relationship matters because it allows you to potentially push off some of those things that they're looking for, right? Like getting access to witness interview memos or decks that you're using internally with the company. All of those things, the external auditors just want that information as quickly and in whatever shape it is. But that privilege consideration is there, and managing that and ensuring that, if this thing does break bad publicly and ends up in litigation, that you're not waiving that privilege and some crafty plaintiff's lawyer isn't using that verbal disclosure as, the crack in the chink in the armor to get underneath the privilege.
I was going to mention on the topic of just disclosure generally, we talked about timing of disclosure and what's the, in the context of, for example, a government investigation. I've seen some clients that want to make a disclosure at the time of receiving the subpoena, or in an SEC case, it would be the difference between a formal order being in place versus not is really the line. It's obviously, of course, facts and circumstances in every case, but it seems in most cases, it seems like the the appropriate time is at the time of, for example, a Wells notice in the SEC context, or perhaps a target letter in the context of a DOJ investigation, as opposed to something sooner, just the request for information or the like. And so I think it's, of course, those are kind of guiding principles, but I think they're important to know.
So one of the other issues that always arises with disclosure is timing. Crises don't wait and occur at optimal timing. I've had plenty of cases where they occur 2 weeks before management rep letters are going out, or a week before an earnings call, or 48 hours before an earnings call, and then you have to start making really hard decisions about, do we push off our disclosures, and everyone knows what happens when you do that? Do we try to get outside counsel in and just swarm the company and try to figure out as much as they can as quickly as they can? Felicia, from your perspective, how do you manage that issue? Because you have this schedule always in place as a public company. We're not there yet where we're going to have reporting obligations every 6 months. Maybe when we do this next year we will. But right now you have quarterly obligations, and you know exactly when they are. And when these things come up, you could be 24, 48, 72 hours in advance of an earnings call.
Yeah. So I think the first thing that I would do is breathe and make sure I didn't make a stupid decision because I was under the gun. So I've seen a lot of people do that. But to your point, everyone needs to take a breath and determine, you have to be driven by only what you know, okay? And if you really don't know, I would be an advocate more of doing nothing than doing something. Yeah, depending on the crisis, like if outside counsel can get in here, and I think I would have them swarm in and try to figure it out anyway. But I would be circumspect of, if I did disclose something, it would be the bare minimum that I factually knew. Maybe a nothing disclose, like something happened, in a nicer way to say it. We still don't really know what happens if there's some earnings call and it's going to get out. One of the things that we really rely on is our disclosure counsel. I don't know if many of you are in the room. When we spun off from big GE a few years ago, we weren't in the business of sort of doing our own Ks and Qs and all of that. And so we really relied on, one, we want to make sure we're aligning on what, and also how to say it. And, people have been doing this for a long time. There's been all the crises that you're talking about, Patrick. They've happened somewhere before. And sort of like, what is a good standard? What is enough to, educate our investors, but not unnecessarily or unduly alarm. Mm-hmm. And so it's, but it is a treacherous path.
What about other disclosure obligations? If obviously the big quarterly annual disclosure obligations imposed by the SEC are there. What are some other things that, whether it's private companies, public companies, that members of the audience should be thinking about that could impact both the timing and pace and velocity of an investigation, but also what it is they have to disclose?
Well, one thing that comes to mind, if you're disclosing it in your financials, have you disclosed it to all relevant investigating agencies? Right, because it's one thing if you're already getting the subpoena for, like, DOJ, SEC is already involved. But say that there's an international angle and that you haven't, believe me, they're sweeping all of these filings globally now, right? And so whatever you're saying here, do you need to be telling some other authority? Do you need to be telling some, as I said, some underwriters, or if you're in due diligence, a merger partner? I won't speak to the private company piece. But
I was going to add on the private company side of things, some things you have to think about are, whether there are agreements in place with third parties that a private company has that require disclosure under certain circumstances, and whether this triggers those kinds of disclosures. One that comes to mind is perhaps a loan agreement with a bank or an insurance policy of some sort. And so having a really good understanding of what all those agreements are and whether and the circumstances under which a disclosure obligation arises is really important. The other is in the context of a private company is are they doing a private placement raise at the time? And if they are, then you need to think about whether they need to make a disclosure to the prospective investors, or else they're potentially opening themselves up to either an SEC action in the future or a private action by those investors if things go sideways in the future.
Yeah, no, those are really good points, John. I mean, I know from experience with 40 Act RIAs that you're often dealing with investor letters and quarterly communications that get pushed out to investors, and you have to figure out what it is you're going to say, or whether in the first instance to say something and then how you say it, or you've got a borrowing base certificate that you have to send off to your lender, or there's a pipe, whatever it might be. Those, there are things that could hit a private company that, yes, not at the same speed and frequency as a public company, but that are still going to matter and could still have those same very dire consequences if someone doesn't do what they ought to be doing.
For sure.
So, one thing that always is on the mind, I know, of outside counsel when we get called about a crisis is, how does this come across in-house counsel's plate? What are the sources of a crisis? Is it, it's usually not the CEO walking in to the general counsel's office and saying, I screwed up, I did X, Y, and Z, I was arrested last night for drunk driving, whatever it might be. It usually comes in some other way. So, how do you prepare those channels to ensure that you're getting that information quickly so that you can react? And Felicia, we'll start with you.
Yeah, so they come from a variety, particularly internationally. It can come from a dawn raid in Europe. It can come from a request, a government, issues a request or a subpoena. Primarily, though, if you have a well-functioning compliance program with we call it our ombuds program, but, the ability to raise a concern both internally and externally, either anonymously or not anonymously, that's where most of them will come in. And so, do you want me to talk a little bit about sort of how to deal with that when they do come in?
Well, why don't I turn it over to Ann for a minute? So Ann, if we're talking about internal whistleblowers, whether they're named or anonymous, how do you ensure that that program is actually channeling people or encouraging them to report through those channels rather than take it to a lawyer, a plaintiff's lawyer, or right to the government?
Yeah, it's a great question. So it really, from a control perspective, it stems from the tone at the top. So oftentimes we'll be called in to do a tone at the top assessment or audit to ensure that exactly what you're saying, Patrick, that there is a way for employees to feel comfortable to be able to voice their concerns upwards, and that it is happening on an ongoing basis, and that not only they could voice it upwards, but that their concerns are being answered. Whether or not their concerns are valid is a different point, right? But is there a comfort level among employees to feel that their voice can be heard in the first instance, right? So I think it's really important to understand is your senior leadership, is your senior management, are they fostering a culture of compliance, a culture of following the rules, following the code of ethics, following all of these things, so that if somebody isn't, an employee's basically filing through like a speak-up report, or there's various different hotlines that they can use. Is that communication coming upwards, which companies clearly hope it is, instead of employees just feeling that their voice can't be heard, and then they go outside of the organization to various different agencies reporting those concerns.
So sticking with tone at the top, if using the hypothetical that we've been talking about, the CEO engaged in alleged misconduct, if that's the tone at the top, right? He or she is the one who puts the message out. Follow our internal reporting our internal reporting channels, encouraging people to do all that, right? All of the things that you would expect either at town halls, annual audit meetings and the like with the group. But if that person's involved, how do you ensure that someone who has information about that person is comfortable knowing that, if they report it, that the CEO isn't going to stop it, squash it, whatever, and or retaliate against that person for raising what is a legitimate complaint?
All really good points. The way I've seen it work best is if there is that instance example that you mentioned where the CEO has committed misconduct and it is known throughout the company, I think there needs to be a voice from the company to say, hey, we are addressing this. We've brought in external counsel, a reputable firm like yours, to come in and investigate it and see what's happening. And basically, there's then a messaging out to the employees to basically say there will be no retaliation against people coming forward with information. Felicia and I were talking about this earlier, is that, retaliation is an interesting thing, right? Because everybody thinks of retaliation as, somebody getting fired, but that's not always the way that employees retaliate against one another. But I think all really great points that you raised, and those are serious concerns when you have somebody at the top either committing fraud or having some sort of misconduct.
One thing would be important for the employee population to know that in our company, the chief compliance officer has direct access to the audit committee. Oh, sorry.
You might need to move the microphone.
Can you hear me?
Felicia.
Yeah, of course, the board and our chairman currently, is not our CEO. And so there's the chief compliance officer, or me for that matter. I can send an email to the audit committee. It goes right there. It doesn't need to pass through the CEO. And so we have this annual spirit and letter training where our audit committee chair, and it's like videos in various lobbies of different buildings, talks about the importance and that, you can raise things to the board. Mm-hmm. So along with we're doing something about it, hiring I think the more people that know that the CEO isn't where the buck stops is important.
Mm-hmm. Mm-hmm.
No, I think that's great, and it's impressive because you don't often see that. Oftentimes at certain public companies, the board is this mysterious entity that floats above the company. They swoop in on a quarterly basis, have very nice dinners, very long meetings that pull everyone away, and then they're gone, right? But if people know that they're there, that that's what their job is, and that they are an avenue to report to, that can really encourage people, I think, to do what we all, I think, would want to do, which is have the opportunity internally to address the issue before it gets outside the four walls of the business. Mm-hmm. So let's talk about whistleblowers, because I think they obviously come in all shapes, sizes, and whatnot. John, let's talk about internal whistleblowers. When you're thinking about an internal whistleblower, what do you think are some of the most important things that in-house counsel or outside counsel can do when they learn that there is an internal whistleblower who's raised a concern about a CEO's alleged misconduct?
So, I think when I think of whistleblowers, I think they come into all shapes and sizes for sure, but kind of two categories. And one is, employees or insiders who care about the company and are either correctly or incorrectly blowing the whistle on what they believe to be misconduct. And then you have the other, which is perhaps an employee or an insider who's disgruntled because of scenario X and blows the whistle or basically makes a complaint about scenario Y in an effort to really retaliate against the company because of the other unrelated situation. I found that the authorities, the SEC or the DOJ, they tend to view credible from the outset the the whistleblower complaints until proven otherwise, and vice versa with the intern inside of the company, where the company's initial reaction often is that this person is a disgruntled employee and making up this complaint. Mm-hmm. I think that having regardless of which camp the whistleblowers fall into, it's super important to have a process in place by which the whistleblower can have a direct line of communication with folks who can report back information about the investigation and make sure that they feel heard and make sure that they know that their allegations are being taken seriously. And that has lot of benefits, but one of them is that it makes it less likely that they are going to immediately go outside and relay this information to the SEC or the DOJ. So I think those are kind of the big ticket, high level kind of guidance that I would provide if I was thinking about internal whistleblowers.
So I think you bring up a good point, and I'm going to call it care and handling. So Felicia, when it comes to the care and handling of a whistleblower, how do you do those things that John is talking about? You know, making sure that you're able to go through your process before they go outside, before they get antsy and decide, you know what, this internal process just isn't working for me. I'm going to take it to the DOJ, SEC, you know, go down the alphabet soup. What are some of the tricks of the trade that you can share?
So there's no trick. We all learn this in, you know, we have these discussions and we complicate it. We're human beings, and often, I think my experience is that almost all the time, the whistleblower starts as being they love their company. Mm-hmm. They're part of the company. They want the company to do well. They see an issue, whether it's legitimately they're seeing a problem or not. They want the company to be better, and they want to get credit for helping us be better. And I think you don't get to the point where you're really angry enough to go outside unless there's already been a number of people who have minimized you and not listened to you. So by the time they get to me or to our, you know, it is human being behavior. Communicate, communicate, communicate. Listen, listen, listen. Respect, 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 okay? And so even if they are just, you know, we say disgruntled as though there are people who are disgruntled and are telling the truth, you know, and vice versa. So you just have to, again, breathe, calm things down. And one of the things that we do, I mean, look, if it's a crisis type of allegation, we will often soon hire external counsel. Now, yes, we're engaging the external counsel. They're not completely independent, but they do seem more independent. They don't seem, you know, if the company's bad, okay, well, they're once removed. And I will get external counsel talking to the whistleblower soon, you know, even if you don't want somebody from GE Healthcare in the room, right? Talk to them and really listen and also communicate along the way. Now, the defense-minded part of me is, okay, look, you are getting their story, you are documenting it, you are getting them sort of locked in to what the allegations are, you're getting all of their evidence. Along the way, you can try to mitigate them inappropriately taking proprietary or trade secret information and all of that. And so then at the end, when you report back to them, not with privileged information, but enough to let them know, and you don't confirm what they have thought, then I do think that they're going to think twice, because like, hey, they did hire this law firm, that there's a bunch of evidence apparently to the contrary, and maybe I should think twice. So I think it is step by step, but also multifaceted.
Now, Ann, you've presumably dealt with whistleblowers on the accounting side. When you see whistleblowers coming in, especially internal, you know, what shapes and sizes are they coming from that direction? And, you know, is there anything unique about them that makes them a unicorn in how they have to be dealt with?
Yeah, I think it's a great point. So usually the folks that I deal with are in the accounting group or finance group that are whistleblowers. And I think they find themselves a bit more credible in nature just because they have the financial numbers at their fingertips. So they have more so, you know, not like I overheard this conversation or I think these people are doing this, is that they actually have the numbers as backup. So I think in those types of situations, I mean, I agree with Felicia, like you have to listen to what they're saying, you have to understand what their complaints are, and being dismissive or just saying like, you don't understand the business, you don't understand what's going on, even if you're a low-level accounting person, it's not going to get you anywhere, because they're going to then, you know, feel that there's no mechanism for them to report up in the organization, and they're going to go elsewhere. So I do think, but you have to speak sort of their language, which is numbers. And so I do think it's very helpful when you have a whistleblower that has a finance or accounting background to have somebody who's interviewing them speak the same language so that they understand what their concerns are truly.
And Ann, that's something I'll double down on. I mean, when we do internal investigations with a whistleblower who has that expertise and experience, we bring in those outside consultants, whether it's someone with internal audit background, if that person, the whistleblower is in that internal audit function, accountants, if it's in the accounting or finance department, if it's in the, a scientist, we'll make sure we have a scientist on hand who can both help us understand the data, ask smart questions, but also I think it sends a very strong message to the whistleblower, the concern raiser, that they understand what I'm saying, right? They're not just listening, nodding their head, smile and wave, boys, smile and wave, right? And then just let it go, in one ear and out the other. And they're actually listening and able to understand what I'm saying and then take it in, right? Because like you said, Felicia, they're human beings. Human beings have a very strong BS detector, right? And they're gonna tell very quickly if someone is just mailing it in or doesn't get it, or if they don't think you get it.
Yeah, sure.
John, I want you to weigh in here as well. I mean, what are your views on tactics to help with sort of the day-to-day handling of a concern raiser?
One thing that I've had come up in matters that I've worked on is, folks at the company who were really angry about the allegation itself. And so dealing with the client to make sure that they don't do anything that could be viewed as retaliatory, and to, let them, get them comfortable with the idea that, hey, look, this happens. We don't know exactly what their motives are, but we're going to go through the process, and you got to be patient. And so, but there's a lot of anger and frustration that comes up almost daily based on any kind of, investigation that comes about by way of a whistleblower. So I think about it more in terms of everybody around the whistleblower to make sure that there's no problems with the whistleblower.
No, it's a great point. You obviously, don't want self-inflicted wounds. Right. Mitigate those as much as you can, and then also, do no harm, right? If there is harm to be had, fine, but we around that issue and around that individual don't need to. We have about 3 minutes left, I'm seeing on the clock. One big thing that I think is in front of us every day is politics. And obviously, questions around self-disclosure, they change because we're in a new administration. What isn't something that is a priority for the Department of Justice or the SEC. Those are all changing. Does this new administration and how it's approaching things either change how you view a crisis, Felicia, or how you respond to one?
No. And I think for two reasons. One, we are committed to our culture and doing the right thing, regardless of what may be happening externally. We are going to conduct ourselves in a way that we're proud of. I think our customers and the patients they serve would expect nothing less. So our policies will remain unchanged, and we will keep improving them. But on a practical side too, guess what? The rest of the world is ramping up enforcement actions in the areas of which the U.S. is not. I mean, I get alerts all the time of, the UK now has this new, you have to report about any fraud, essentially committed by anyone, or there's an anti-corruption campaign going on in pick the country. Other countries are going to fill the gap. So from a practical perspective, you need to just keep on doing what you're doing. But really, more importantly, you need to hang on to the culture that you've worked so hard to build.
What's your take on that, Ann?
Yeah, I agree. I mean, I think regardless of the political climate, there clearly is enforcement, but then there's also private litigation as well. So that's not going to go away. So I think you have to maintain, high integrity and good corporate culture for your business if you want to be ultimately successful, regardless of what's going on in the political atmosphere.
John, have you had any experience with clients wanting to either push the envelope under this new administration, or, to Felicia's point, sort of holding the line and, not flipping or flopping based on who sits in the White House.
Yeah, when, for example, the FCPA kind of shift was originally announced, in my head I wondered whether certain companies were going to change their approach, either decrease funding for that type of thing, or basically say, we're going to get into the bribery game, not once has that happened. Every single executive and in-house counsel that I've spoken with over the course of the last several months have just said, this is part of our culture forever has been that we're not going to engage in this type of thing, and they also recognize the practical considerations of there are additional enforcers other than the DOJ, and so keeping that in mind. But it really is a culture thing, and it's been universal in my experience.
That's good.
Yeah,
That's really good.
It's good.
So we're out of time, but before we end, maybe we just go down the road, or down the row. One quick takeaway that you'd like to leave the group with, and start with you.
I would just say tone at the top is really important. I think it's the key to a successful environment and no corporate crisis.
I think one of the most important characteristics of a leader at a big company or as a third-party vendor is to just is to remain calm and measured until you figure things out.
Get an outside counsel involved early to preserve privilege.
Spoken like a true big law partner.
Preferably Willkie.
Thank you, everyone.
Great panel. Thanks, Patrick, and thanks, everybody. We'll be back at 3:30 for a panel on insider trading, and Rebecca will be back up here to moderate that panel. Thanks again, Patrick, and great panel.